Good evening, everyone. So, we welcome you all to the last session for the day, that is National Youth Day Summit, which is the paper presentation session. The papers are based on two broad themes with respect to COVID 19. One is related to cyber crimes during the pandemic, as well as police reforms during the pandemic. In case of cyber crimes, we will be dealing with various sub themes. What are the crimes? Have cyber crimes increased during the COVID 19? What are the aspects of cyber crimes which we came to know about during the COVID 19? As well as we'll also be seeing about the police reforms and what are the aspects related to the police, especially in Indian judicial system and Indian criminal system during this pandemic time. Now I'll hand over the stage to Tanishka, who will be telling you the rules for the paper presentation.
Good evening, everyone. The rules for your presentation will be as follows. Firstly, we'll give you 3 to 4 minute slot each speaker for presenting their ideas. You don't have to go into detail of your research article. Instead, you'll have to present your idea, your conclusion, your suggestion, or your recommendation, which you have written it in your article as well. And secondly, what we expect from you that you can also give idea of the. Yes, ma'am.
Also,
Ma'am, laptop.
during the so basically the rules are 3 to 4 minutes you will get for presentation. During your presentation, try to be crisp and give us an idea of what is there in your paper, but be crisp and to the point. What is new? What is that new thing that you bring to the table? So please be aware of that. Also, there is no need of PPT. So, but if there is a PPT, we'll see, and based on the time, we'll see that if time can be given for presentation or not. Also, all the selected articles will be published in the INBA ebook as was informed earlier also, and we'll share the list after this event. Okay. So now, as a host, what I'll be doing is I'll be calling out your names one by one according to the list that I have, and Tanishka and me will be calling you out, and I'll be sending an invite to you right here on this platform, and you have to accept it. Once you accept it, you have to switch on your mic as well as your camera, and I hope you all are in formals, and you have to start presenting your paper. Okay, please ensure that you don't read out your paper, as that is not good. So you should be aware of what you have written in your article. Okay. Switch on your camera.
First, we have Pallavi Paul from Department of Law, Assam, to presenting her research paper.
So, Pallavi, right now I'm inviting you to stage. You must have received an invitation. Please accept it. Pallavi Paul, please kindly accept the invitation. See, I'll call out your names max to max 2 to 3 times. Then I'll move to the next. In case you're not able to get your chance, we'll consider you at the end because there are other students also. Okay? Just give us a
Pallavi, you can coordinate on the chat box with us if you're here.
So I'm calling out the next name. Tejas. Tejas is here with us. Tejas, I'm inviting you to the stage. Please accept my invitation. Okay, Tejas has joined us. Tejas, can you see the option of raise hand? Please raise your hand. Just click on the raise hand option. Yes,
Yeah.
we can see
Am
you.
I audible?
Yes, Tejas, you are clearly
Yeah.
audible. So yeah, let's begin with your presentation. Tell us your introduction and your article.
Sure. Very good evening. My name is Tejas Hinder, and I am a third year student of BLLB Honors at National Institute University, Bhopal. So, considering it being a youth day, I thought of bringing in a news perspective to address issues that are surrounding us and not go about beating around the bush when it comes to readdressing perspectives of law that have been addressed. So, one such pressing topic that I chose to address was marital rape in India. And now, because we've had a lot of scholars who have continuously argued to us the fact that marital rape should be criminalized, the second exception under Section 375 should be done away with, stating that Article 14 is being violated, Article 15 is being violated, and Article 21 is being violated, and they time and again come and state to us as to what we've got from the JS Verma committee report, on the basis of which the 2013 amendment came into place. I think it's time we step beyond that and actually understand as to what the legal position is in India, which is predetermining the concept as to, or predetermining the existence of an exception. That is what is holding us back from criminalizing it, right? And I do a legal analysis on the basis of a statutory and judicial precedent analysis. And my paper is hence titled Marital Rape in India, What is Holding Us Back from Criminalizing It? Now, contentions, as I said, involve multiple violations of Articles 14, 15, and 21 that has been addressed. They say that sex in a marriage is the only law which does not recognize the right of the wife, whereas most other laws do, which include domestic violence, dowry harassment, etc. Then we had, as I said, the JS Verma committee report. But now what I'm attempting to do here is go around four concepts, which is the centrality of the concept of sex to the idea of marriage, difficulty of proving consent in a marriage, the sufficiency of the existing laws to deal with domestic violence towards women, which comes out as a major contention in many significant judgments. And then lastly, the criminalization that results in interference with privacy in marriage. So taking into consideration all of these and doing a judicial precedent based analysis and a statutory analysis, I do not attempt to create a prejudicial mindset over here telling you that marital rape does not have to be criminalized, but instead what I attempt to do is put forward these interpretations, tell you as to why these interpretations are problematic themselves, right? And these interpretations are put forward without giving prejudice to jurisdictions. That is, these interpretations are of high courts and even lower courts, and only when these are taken into consideration can we bring out this legal change, is what I am of the opinion of. And that is the main assertion, and that is what I have, that is the statement of problem that I utilize for the purposes of writing this paper. Now, coming to the centrality of the concept of sex to the idea of marriage, what we have to understand is that the concept of consent is not arising in does not believe to have arisen in a marital relationship, because the mere decision to get married can be treated as a consent to have sexual relations, since sex is central to marital relationship. And now, if I were to bring your knowledge to Rita Nijwan versus Balkrishna Nijavan, which is a judgment of the Delhi High Court in 1973. It says that marriage without sex is an anathema, and sex is the foundation of marriage. And without a vigorous and harmonious sexual activity, it would be impossible for any marriage to continue for long. And this is where the entire concept of consent was very much destroyed by judicial precedents, right? And this is not the only judicial precedent that we have in line over here. There are multiple other judicial judicial precedents, which include Harvinder Kaur versus Harminder Singh Chaudhary, which include Saraswati versus Babu, which include K. Prema S. Rao and another versus Yadla Srinivasa Rao and others, which create this problem. Now, where do we have a problem legislatively when it comes to centrality of the concept of sex? It is Section 12 of the Hindu Marriage Act 1955, right, which declares impotency or absence of sexual relations as grounds for annulment of marriage. And Section 2 of the Dissolution of Muslim Marriage Act 1939 also does the same. And these laws further assert that the importance of sex in a marriage, these laws assert the importance of sex in a marriage and recognize inability to consummate a marriage as grounds for nullification of such a marriage. And this is where the problem arises. Now, the second step of the problem is the difficulty in proving consent. Now, most of us rely on scholarly interpretations of the very concept of consent for the understanding the very concept of consent, and I rely on Black's Law Dictionary. And Black's Law clearly defines consent as a concurrence of wills, and express consent is that is directly given or either lira voice or in writing. And there's another concept which is implied consent, which, as we know, is manifested by signs, actions, or by any sort of conduct. Now, when we take this into consideration, it is this idea of consent that is very difficult to prove in any marriage. The existing methods to check if rape has taken place or not is extremely outdated and is based on the assumption that a woman remains a virgin before such rape takes place. And there's a test that is being put forward by courts in this regard, and this has been quoted in notably in Lavanya Shobhone Arvind's article, which has been published by the Oxford University Press, which goes ahead and states that there's a two-finger test. There exists a two-finger test, but despite the fact that the two-finger tests have been either abolished or been made inadmissible in rape trials as part of courtroom proceedings, these tests ought to continually be used. And despite the absence of and considering the absence of this very two-finger test in a marriage, considering the previous concept of centrality that I just spoke to you about, and also the fact that there is an implied consent that is assumed even through judicial and legislative interpretations, it gets problematic in the entire process of criminalization. Now, there was something called the Guidelines and Protocols for Medical Legal Care for Survivors and Victims of Sexual Violence that came up by the ministry, that was brought about by the Ministry of Health and Family Welfare of India, and it is not fully followed. Right, and this document has already made a number of recommendations as to what to do, which was notably noted by the Supreme Court in the 2017 judgment, wherein to a certain extent exception 2 was attempted to be done away with. But these guidelines have not completely been adopted, and there is no judicial precedent pushing or creating some sort of leeway for states to go ahead and implement this. Now, the other problem that arises is with regard to the sufficiency of the existing laws to deal with domestic violence towards women, and this is where the courts have mistaken. Right? Why have the courts mistaken? The courts mistake it because they think protection of, as we see in multiple judicial precedents like K. Prema S. Rao and another, and Harvinder Kaur versus Harminder Singh Chaudhary, and even Juwairiya Abdul Majid Patni versus Atif Iqbal Mansoori, as I've stated in my research paper on footnotes number 6, 7, and 9. I'm sorry, 6, 8, and 9 respectively. They say that Protection of Women from Domestic Violence Act 2005 defines domestic violence in Section 3, and it is very much inclusive of marital rape. And Section 18 of the Act itself gives the magistrate power to hear both the parties out in a case of on a prima facie basis, satisfied that domestic violence has taken place or may take place. Right? And Section 31 kind of the Act kind of talks about penalties that could be imposed, and then you also have Section 498 of IPC, which talks about cruelty suffered by a woman at the hands of her husband or any other relative of the husband. So they think this suffices, but this particularly does not suffice because the act of rape in itself is to be considered as rape.
Thank you, Tej. Thank you.
If I could just take a minute extra, I just have my last point to make.
All right, just a minute for you, okay? Just a minute, please.
Yeah. Indeed. My last point is with regard to criminalization resulting in interference with the privacy in marriage, right? And this is where the judgment of K.S. Puttaswamy and Harvinder versus Harminder Singh Chaudhary come into place, right? And why do they become important? So basically, the court in this case came and said that the introduction of constitutional law into the ordinary domestic relationship of husband and wife will strike at the very root of that relationship and will be a fruitful source of dissension and quarreling. And this was a fundamental misinterpretation that was made, in addition to which K.S. Puttaswamy came and interpreted the Hindu Marriage Act and said that the privacy would be infringed if there's any law that violates the private space of a couple. But what these judicial precedents mistook is the fact that private space did not necessarily go ahead and give permission to commit such an activity, and this is where it becomes problematic.
Okay, Tejas, thank you. You can exit the stage now.
Yeah, may I know where the option is to exit?
Yeah, I'll remove you, okay?
So next up we have with us for the presentation is Roshni Mulchandani from Nalsar University. Roshni, are you here? Roshni, please raise your hand. So, Roshni, if you're here and if there is any connectivity issues, you can message on the event chat box. Moving on to the next presenter, we have Rachita Thakur from Department of Law, Punjab University. Rachita, please raise your hand.
Rachita has joined us on stage. Okay, waiting for her. Hi, Rachita. Please switch
Am I
on your.
audible?
Yes, you're audible, dear, but please switch on your camera.
I guess there's something wrong with my connection. My camera is on.
Okay.
Rachita, you can try for turning on your video. Otherwise, you can start with the presentation. And strictly, you will get 3 to 4 minutes, not more than that.
All right. I think there is some problem with her internet connection, so we'll move on to the next person.
The next up we have Ramisha Bhardwaj from Symbiosis Law School, Hyderabad. Please raise your hand so that we can invite you to the stage.
Over to you, Ramisha. Please switch on your camera.
Right. Am I audible and visible?
You are.
Yeah, but my camera is on. Oh, yeah, just a second. Yeah.
Yeah, we can see you. Okay.
Right. So, good evening, everyone. As introduced, I am Rimsha Bhardwaj from Symbiosis Law School, Hyderabad, and I'm currently pursuing my second year in BBA LLB. And the topic, there were two themes provided, and the topic which I have chosen is related to the cyberspace. And the name of my topic is Pandemic and Indian Cyberspace. So, cyberspace is something which is not very uncommon to, especially youth. When we talk about youth, it's something which everyone knows. Internet has made things very useful for all of us. As we say, we operate, we read, we buy, bank, everything is shifted online because of the pandemic, of course. And when we talk about the problems which have occurred in this era is related to online frauds. So basically main two divisions which are provided in my research as given in my research are online frauds, and second related to the cyberspace when we talk about social media and teenagers. So, starting with online frauds, when we talk about phishing activities or hacking, ransomware activities, these all activities have created a much of a problem in every era. And WHO reports have confirmed. I have clearly mentioned in my article that WHO itself has confirmed that there have been attempts in hacking the datas which were related to the patients of the whole nation or whole country and the many other countries. Spy attacks and extortion attacks were there on the people who put in their information, sensitive information online, being unaware of the fact that people are present and trying to do such activities. As per the data, 43% of the attacks were carried out in the last quarter itself. So this is a very big figure, which anyone can clearly understand that this might create problems. And when we talk about India specifically, the problem related to health sector, when we talk, because the concept was related to the pandemic, India has seen a remarkable 86% spike in the cyber attacks during the time of March and April 2020. This was mainly the Indian medical institutes have also confirmed that there were attempts again to take the data of the patients, and in whatever sense it could have been used by many agencies or the people who were present for that. Next one is related to the social media trends, frauds, and the teenagers. So, being the youth of the nation, it's something which is very common these days. Most of us must have experienced, or many of us have read about the reports that are present related to the fake profiles that people are creating and then asking you for the pop up links and clicking on the links and making sure that you click on the false link and share any personal data or information which in some or the other sense can be very useful to the people. These are things which are very important to understand, that if we connect the social media with the law, how it can be treated, the main problem is related to the malicious intention of the person who is present to hack the things. So if the person is doing it with any of the intention which is not really good for the other person, the main problem arises that any information can be used in whatever sense which can help the fraudster person to share the offensive content online without the consent of the person. When we comes to laws in India, there are much laws, and with the incoming of IT sector, IT law 2000 has clearly made so many offenses very taken them very seriously, such as hacking or ransomware attacks are punished, and many other punishments are also provided. But the main problem which lies are the laws which are implemented are not particularly looking into healthcare sectors or the sectors which are very important for the country. When we talk about the pandemic, healthcare sector is much infected in this era. The next is the problem related to the territorial jurisdiction, how the jurisdiction, if a person is sitting in Australia, might attack. So the system lacks concreteness. The main important point which is to be noted is that there is need for concrete results, how the laws can be so much stricter that there are no chances for the person who can hack or go into some wrong details of a person. The last problem which arises is related to the evidence which can be easily corrupted, since everything is on software and it's all technical, so even a slightest glitch can hamper the clear use of the evidence, which is very important. So at the
Rimsha,
last,
sorry for the interruption, but you have a minute to wrap up.
yeah, I'm just wrapping it up. So in the end, all I would like to conclude or suggest is that this is something which is very important for every person to understand with the growing age, and especially in the time of pandemic. The main reason why a data can be important is one kind of a data can be important for certain kind of individuals, but it might not hold the same value for the other. So it's important that the nations come together and find a good way or the good solution out to this problem. Thank you.
Thank you, Rimsha. Next presenter we have with us is Rachita Thakur from the Department of Law, Punjab University. Rachita, please raise your hand so that we can invite you to the stage. Rachita, please switch on your video. Yes, you're visible and audible. Over to you, Rachita.
Good evening, everyone. Okay, thank you. Good evening, everyone. My name is Rajita Thakur. I'm currently in second year of my LLB program from Department of Laws, Punjab University, Chandigarh. My topic for presentation is the status of police laws in India, a critical analysis. My article emphasizes basically on the current police regime in India by analyzing the problems associated with it, and making way for the reforms that have been done in past and so far, what are the reforms and what are the recommendations that I would like to give. So police and police order are the state subjects as prescribed as provided for in the seventh schedule of the Constitution of India. Therefore, all 28 states in India have their own police force, which are in turn governed by one single central legislation, that is the Police Act of 1861, which was legislated by the British in after the revolt of 1857. And since then, it has been the basic instrument that governs the functionalities of police force in India. However, time and again, various experts, various policymakers have iterated the need to do away with this regime, as it is an age-old regime, an age-old act, and India needs a better implementation, better act to implement with. It deals with a lot of, it has a lot of problems associated with it, which demand immediate attention. To start off with, we have the problem of custodial crimes, custodial death and custodial torture, which have become a routine in India. As per the crime report 2019, 85 people have lost their lives while being in custody, and around 4,068 cases have been registered against police personnel for violation of human rights. I mean, this is something, human rights amounting to encounter killings, illegal detention, custodial death, torture, etc. And though the crime in India is said to be under reported, crime as per official data has increased. The cognizable crime rate in India has increased by around 7% from 2018. And there's a parallel shift in the commission of crimes. Thereby, the criminals have adopted a more complex way of committing crimes. Thereby, we all know that we all are aware about the cyber crimes that have increased. The surge in the cyber crimes indicates the increase in cyber crime has been by around 81% from 2018 to 2019. There is a complete shift in the pattern, and what has remained, and the irony is that the crimes have changed, the pattern of crimes has changed, but what remains unchanged is the very act that governs, or the aim of which is to curb crime. That is still the same old act. And another problem associated with the police system in India, the policing system in India, is that the police personnel are often overburdened with tasks. One, due to the lack of proper staffing. Considering the second most
Rachita,
populated country in India is, yes,
Rachita, please wrap up in a minute.
so, considering the second most
Okay.
populated country in India, only 150. India has 151 police personnel per 1 lakh population, whereas the sanction strength is 198 per 193 per 1 lakh population. So we see the wide gap there. It is undue political interference is also another problem associated with this current police system. Government authorizes and exercises its control over the police personnel. It's not that reforms have not been the topic of debates in India. They have been, but the government has never adopted those suggestions from the various committees and various policymakers. However, Supreme Court in Prakash Singh versus in a very landmark judgment, it was in Prakash Singh and others versus Union of India, laid down 7 directives and asked the states to comply with these 7 directives, whereas only 2 states, Arunachal Pradesh and Nagaland, have complied with them completely. So we are at a stage
Time.
where there are rules, there are
Rachita,
just a minute,
Rachita,
just
please
half a
wrap up
minute only.
quickly. Sure.
We have guidelines, but India and the government does not does not adhere to those guidelines. India aspires to become a superpower, but how is that going to happen if we don't have a proper foundation at ground level?
Okay,
So
Rachita, thank you
India,
so much. We have other speakers as well, dear. Okay. Okay, dear. Bye bye. Thank you
thank
so much for your presentation. Really amazing.
So next up we'll have with us is Devi from Savitri Bai University, Pune. Please raise your hand so that we can invite you to the stage.
Okay, am I audible?
Yes, you're audible and visible as well. You can start. Over to you, Devi.
Okay. Good evening, everyone. My name is Shri Ranjan. I'm a third student from Pune University. Today, I'll be presenting on the article titled The Impact of COVID-19 on the Rising Cybercrimes. So, my article is primarily based on how the pandemic has triggered an exponential upsurge in the number of cybercrimes around the world. And as far as my oral presentation goes, I have divided my presentation into three parts. I'd be starting with the introduction, followed by the trigger factors for the rising cybercrimes, and ending with the conclusion. So, as we all know, the COVID-19 pandemic has led to an inevitable surge in the use of digital technologies. This is mainly because of social distancing norms and nationwide lockdowns. Most of us have had to adjust to new ways of work and life. The lockdown has resulted in most of us taking to the internet and internet based services to communicate, interact, and to carry out our daily responsibilities from home. Also, education is another domain in which there's a dramatic shift to an online mode of functioning. Now, this situation has exposed most of us to a range of cyber risks that could have dreadful consequences if not handled properly. However, the risks associated with cybersecurity have always been there. But why a sudden rise? Now, this is mainly because of the percentage of population that is connected to the internet right now and with the amount of time being spent online. Now, this combined with the sense of confinement and the fear and anxiety caused due to the lockdown has made the cyberspace a safe haven for potential hackers out there. So another very important matter of concern is that vulnerable segments of our population, such as children, have now turned to online mode of learning, for which they have to spend most of their time online behind their screens. So this is where the evidence suggests that these vulnerabilities are being targeted by fraudsters out there to take out personal information, to carry out various other malicious activities like running phishing campaigns through seemingly genuine websites that appear to be providing information on COVID-19. Also, attacking the systems of international organizations such as the World Health Organization, or trying to obtain unauthorized access into the systems of companies or people working with compromised networks. Now, to talk about the trigger factor. Now, the rampant or the sudden spike in cybercrimes can be best explained with the help of routine activity theory. Now, this theory stipulates three basic elements for a crime to happen. Now, these are a likely offender, a suitable target, and the absence of a capable guardian. When these three elements come together in time and space, a crime is likely. So, if we take an example, when a child is attending an online session, in the absence of a capable guardian, he or she becomes a suitable target. Now, this is how a crime happens in this particular situation. So, in order to conclude my presentation, I'd say that when it comes to cybersecurity, just like public health, prevention is better than cure. So, by following
Devi,
simple precautionary guidelines
please
and
wrap up in a
safety
minute.
procedures, yeah, sure. I'm just done with it. So, by following simple precautionary guidelines and safety procedures, as I've mentioned in my article, we'll have a better chance of fighting against the people who are trying to capitalize on the chaos of this pandemic. Thank you so much, everyone. Over to you, Tanisha.
Yeah, firstly, I would like to request everyone to kindly share your ideas, your conclusions, recommendation, or any kind of suggestion you have from your topic. Don't go into very much details, and we can just quickly wrap it up with your ideas. Thank you. Over to you, Sneha.
Hello. Hello.
Hi Sneha, can you please
Yeah.
switch on your camera, dear?
Yeah. Actually, it showed that the camera is switched on, like while joining. So, uh, 1 second. Okay. Yeah. This. Okay. Yeah. Hello. Am I visible?
Yes, you're visible and audible. You can start, Sneha.
Okay. Thank you. Good evening, everyone. So, thank you for giving the opportunity to present the paper today. And my name is Sneha Rath, and I'm a second year law student from National Law University, Odisha. So today the paper which I have submitted, it talks about it deals with cybercrime, a broad topic which was presented, and how cybercrime plays an important role, and what are the concerns with respect to cybercrimes which have increased during COVID-19. That is what my paper addresses. Now, as cybercrime is not a very new word or a terminology which people are aware of. It's something which has been in existence even before COVID-19. However, in my paper, where I talk about how cybercrimes have surged during COVID-19, I have tried to address one important aspects of technology, especially internet, which is the vulnerability of how our dependency on internet has increased, because of which cyber crimes have become more penetrable in our lives. Now, having established that, I would like to state that my paper, with respect to the dependency on remote technology, uh, it addresses three aspects. The first aspect is with respect to the student's life, as to how even before COVID-19, the number of people who were using remote technology, be it through any platform or any devices, has increased more during the COVID-19. Then it comes to our interaction with respect to different kinds of transactions which take place, not just commercial, not just social interaction with people. However, a lot of different kinds of interactions which take place. How because of that, how that has increased, and how cyber crimes and how these kind of interactions have become more vulnerable to cyber attacks. And the third aspect which I deal with is the justice system, where I have, since this is a short article, I tried to address how different institutions, be it the court procedures which are taking place, not just in India, but also in the international forums, where we have the international arbitrations going on. We have other court procedures which are going on, or even the United Nations meetings, or even other events which are taking place. How their dependency has increased on remote technology. Having said the three aspects which my paper has tried to address, I would also like to elaborate on the fact that today, globalization, which is a concept which has become more relevant than before, be it in academic world or be it in general, globalization is something which is, I tried to elaborate upon it while discussing cyber crimes. The reason being that post globalization, which surged with with US and other powers coming into picture, we had post globalization, we had
Hi Sneha, sorry to interrupt. You just
Okay.
have a minute to wrap up, dear.
All right. All right. So, since I already established as to what my paper has addressed, I would like to summarize by concluding that cyber crimes have increased more than before, and we using platforms like be it Gmeet or be it our Zoom or other platforms which we are using, people have become more susceptible and more vulnerable to these cybercrimes. The reason being, whether you are a literate person or whether you're an illiterate person, it no longer matters, because many educated people have have observed to become susceptible or more vulnerable to privacy concerns, which have increased. And privacy is one of the important aspects which my paper has also tried to address with respect to it. Thank you.
Thank you, Sneha.
Thank you, Sneha. Next, moving on to the next presenter, we have with us is Bijani Patel from KIIT School of Law. Bijani, please raise your hand so that we can invite you to the stage. Bijani Patel, are you here? Okay, Bijani, if you're facing any issues, you can post us a message on the event chat box. Moving on to the next presenter, we have with us is Aarti Bhardwaj from RGS IPL IIT Kharagpur. Please raise. Yeah.
Am I
Over to
audible?
you, Aarti. Yes, you're audible and you're visible as well.
Yeah, thank you so much. Good evening, everyone present over here. I am Aarti Bhardwaj and I am from IIT Kharagpur Law School. I am in a second year. So I have chosen the topic which is police reforms. And basically, my research paper works on what is its implementation, what is the existing act which is prevailing in India, and still it's in still it is in force, and what is the people perception about the police. So yeah, this topic is already discussed previously to me, and since I'm not going deeply into the police act, which is the 1861 act, the jurisprudence of the police act was that it was made by the britishers during 1861, and after the revolt of 1857. So basically the act was performed or the formulated just to suppress the Indians by the Indians. So it was a strategy of divide and rule by the Britishers to be formulated. But going through that, what are the problems existing in police act, and why there is no reformation in a large scale which is being implemented by the state. So there was our National Police Commission in 1977. It was formulated to give a report on what are the reformation to be carried out for the Police Act and how the policy should be implemented. But at that time, by the ruling party, even the media and scholars have ignored this particular report, and there after that a committee, lots of committee has been formed, like Soli Sorabji committee was formed, J.S. Verma committee was formed in Nirbhaya case as well, regarding the reformation of the police. Even landmark cases like Prakash Singh versus Union of India, where Supreme Court directs some seven directions were provided. But since Supreme Court is in a role to advise something, it cannot make a law. Making a law is of power for the legislature, and the legislature need to understand that whatever is suggested on a very fact, is suggested on a material fact which is being scrutinized. So making a committee and then forming some report and not implementing is not, it cannot be said to be a proper in a way. I would like to quote Justice P.N. Bhagwati statement in one of the case of Motilal Padmavat. He said that law is essentially a social process, and justice is the end product. So ultimately, we need a justice. So there must be some changing values to the law, which is being best suited for our present scenario.
Sorry for the interruption, Aarti. You have a minute to wrap up.
Sure. So already problems has been cited. So what is the solution that we need to talk about? I think that the National Human Rights Commission of the state is only advisory body. So it has to be given a more power to enforce the state to use reformation in their act, because every state is not using the most updated one reformation, and there must National Security Commission is also set up. So they should be given a more vital power to scrutinize the administration of the police, which is being subject to the state. And in article 31 to 30, 36 to 51 says that the directive principle of the state policy is given, which is the moral values of the constitution. So it is the state responsibility. The state should given a full responsibility to enact those laws and to scrutinize those things.
Thank you
Thank
so
you.
much, Aarti. Moving on to the next presenter of the day, Saksham Katuriya from Mj Pru University. Saksham, please raise your hand. Saksham, are you here? Over to you, Saksham. Saksham, you're not audible to us. Saksham. Saksham, you're visible, but your audio, there is some issue, I believe. Can you... Saksham? Saksham, please try again to connect. Saksham, you can just try and reconnect with us. Till then, we can call our next presenter of the day. Next up we have is Dhaval Cheda from Siddharth College of Law. Dhaval, please raise your hand so that we can invite you to the stage. Dhaval, your audio is... no, you're not audible. You're visible to us though.
Dhaval, please check. Have you connected the audio in your computer? Just check that whether it is receiving the signal. Just check the audio jack. I'm not able to understand what you're saying. Sorry.
You can write in the chat box, Dhaval, if you want to coordinate something. No, the audio is not there. The video is there. We can see you, but we cannot hear you. You can check the audio jack for once. Dhaval, we cannot hear you at all. Presenters, please take care that you connect with your audio while we send you an invite, and you allow and give the permission, accept all the invites we are sending to you. Video, audio, the laptop might be reflecting different various permissions. So take care of that as well.
Am I
Yes, you're
audible?
audible now, Dhaval. Over to you. You can start quickly.
Oh, okay, great. So today I'm going to discuss something about cybercrime, which is the topic. A lot of presenters before have given valuable points on different aspects which are covered in cybercrime. I will be very short and concise, no legal terms, no sections, and no legal maxims even which I will mention here. Just a general idea. So cybercrime, as the word suggests, it's a crime, it's a criminal activity which causes a negative impact, and which is conveyed through a mode which is moreover used on a normal terms. So basically, when you have yourself connected on internet or when you use few electronic devices, there are certain informations which are being conveyed from one system to the other, and this information is something which is very confidential in nature. Now these hackers are present there to collect this information and misuse it in a manner which might be detrimental for you. So this is basically more over about cybercrime. What I would emphasize here is there was a good point which Rachita stated that the IT Act, which is not yet altered despite of there being several forms of reforms which they have brought in. Even Devi, which she mentioned the three aspects and the methods which are involved in cybercrime. And further, Sneha even stated about the judicial system and the international arbitration and various other forms which are being used to deal with cyber laws. Now, just few things which I want to state here is that as we are in pandemic and we are still facing this COVID-19 scenario, facing a lots of issue, and we are still more reliant to internet and systems. It would be much more better for us if we try to restrict ourselves, use proper encrypted connections, try to use VPNs if possible, because VPNs are the safest mode so that your identity and your IP address is not detected. Also, you need to understand that you have to be aware on clicking several links, because there are few links which are meant to infect your system, or which are meant to catch off all your confidential information. So it is very important for you to be safe in those aspects. Always use authorized links. Do not try to open anything which is available in public, and which is not even authenticated, or which is given a proper reference to. These are the few points, and in my paper even I have suggested all different information about cyber crimes. But these aspects are required to be understood, because we being a law professionals, we are aware about what things and what kind of situations can happen and how can it affect you. So it's also important for you to spread awareness and spread this information to several different people who are there present around you. Try to spread this word and make this thing more public. Try people to get informed about cyber crimes and the effects which it could cause, and how can they prevent it, how can they fight it and restrict themselves from being affected from such forms of scenario. So just ending on a note that kindly be safe, try to keep your information safe with you. Be assured about the things which I have specified and other information which you would find online on cyber crimes, and how could you prevent yourself from being infected from such cyber crimes. Thank you so much.
Thank you, Dhaval. It was great listening to you. Moving on to our next presenter for the day is Shivani Bhardia from School of Law, Galgotia University. Shivani, are you here? Please raise your hand so that we can invite you to the stage. Shivani Bhardia from Galgotia University. Shivani. Okay, Shivani, if you have any connectivity issues, you can connect with us or drop a message on chat box. We'll invite you in the next slot. Moving on to the next presenter we have with us is Krishnanu Ghosh from School of Law, UPES. Krishnanu, please raise your hand. Over to you, Krishnanu.
Thank you. Good evening, everyone. My name is Krishnanu and I am pursuing BLLB Energy Laws at School of Law UPS. My topic for the topic on which I have written my paper is need for a police vis-a-vis political reform. Now, as you all know that during this pandemic, there have been a lot. I mean, most of the activities have been dealt by the police, and there have been a lot of issues reported as well. So, apart from going into the details, intricacies of what actually happened, let me just point out what are the key points that I have delivered, or what is my conclusion, what is the take of the paper. So, first and foremost is that community police. We have to introduce a lot of community police into our system, and there are a number of states, like for example, Kerala, Tamil Nadu, where community police have been established, and the results have been very exemplary. So instead of just following this practice in a few areas, I think it should be followed in all the places, in all the cities, in all the states of India, because apart from the public assistance, no social reform can be taken. The second is that the directives of Prakashing, and I think previous speaker had also mentioned this topic and this case. So the directives of Prakashing versus Union of India, where the Supreme Court gave a number of detailed directives to be followed, but to be followed by the central and the state government. So those directives, it has been more than 15 years now, that those directives have not been followed in letter and spirit. So the other thing is that those directives should be followed. Third thing is that in the police department, there are not a sufficient number of police people in this organization, in this police department. So it is highly understaffed. So other thing is that more number of recruitments should be done to so that more number of people can be approached. The other thing is that the working hours. I mean, the people who are into this organization, who are the police personnel, they do not have a defined working hours. For example, in other industries, we say there is 7 to 8 hours of working hours, but in police, it goes on for more than 10 or 12 hours of continuous working. So that has to be regularized and kept short and specified that within so and so time, these people should be working. The other thing is that the people, I mean, policemen should be given promotions and incentives according to the cases they have solved or according to the assigned work they have done on a given time. So the more you give these such kind of incentives and promotions, these policemen will be encouraged to work. Now, one of the things is that in Prakash Singh versus Union of India, the Supreme Court had said that there should be a fixed tenure for the senior personnel. But what I want to say is that there should be fixed tenure for all the people or all the personnel who are working, not only for the senior top brass, but in fact all the people, so that there is no political intervention, no political influence into the while working in it. Now, the main thing which I would like to say to resist the political intervention or political influence is that there should be an internal department should be created where all the personnel can go and report to in case there is any political influence, or in case the politicians or the influential people are intervening or trying to manipulate the investigations. So such an internal department such internal department should be there, and those internal departments should be spearheaded by the top officials of the police department, members of the civil societies, retired judges of the high courts, say Supreme Court, or even the lower courts, and even some senior bureaucrats representing the government. And these people will look into the matters, and in case there is any such influence by any outside people while the policemen are working or trying to investigate the matter, they will deal with these situations. So these are the key takeaways for my research paper. Thank you.
Thank you so much, Krishnendu. It was a pleasure listening to you. Next up, we have with us is Nandini Tripathi. Nandini, are you here? Can you raise your hand? Nandini Tripathi. Saksham Katuriya, are you here? We just missed out on your presentation. If you're here, we can invite you and you can present it. Saksham Katuriya, Nandri Tripathi. Saksham is here. Saksham?
Am I audible?
Yes, Saksham, you're audible, but you're not visible. Can you switch on your camera, please?
I don't know from my side. Video is open.
Saksham, your audio is clearly there, so you can just start if you wish so.
I don't know. Maybe my
Saksham, you can start with your presentation. You're audible to us. Saksham, am I audible to you? Saksham Katuriya? Saksham?
hello.
Yes,
Hello.
Saksham.
Before I say anything, I would like to thank INBA for giving an opportunity for law students like me to present before one of the best in the legal field. Welcome, ladies and gentlemen, and a very warm welcome to our very honorable and respected guests who are present here. I am Saksham Katuriya, final year law student of BLLB, your friend, your colleague, and our honorable and respected members or guests looks too young, too beautiful, and too charming to say like their younger brother. Some might think that the honorable is usually used out of respect.
Hi, Saksham. Can you please wrap up because we are short of time? So please start with your presentation. What is there in your paper?
All right. As being a future criminal lawyer, the very sole topic which I chose today is the perception of police in the mind of ordinary people. India is considered as the largest democratic country in the world. Democracy is defined by the participation of broad values and different ideas, which includes both the compliments and criticism about procedures regarding elections. Law enforcement agencies such as police are considered as the center of democratic society, which has role not only to enforce law but also to prevent crimes. They have a mandatory role by keeping in mind the rule of law and not getting influenced by any powerful leader of the party. Law enforcement agencies are supposed to solve the problems of the civilian, as all human beings are born free and equal in the dignity and rights. Human rights derive from the inherent dignity of human person. Law enforcement official shall at all times fulfill the duty imposed on them by law by serving the community and protecting all persons against illegal acts. When it comes to trust the police, a simple survey conducted, which is known as Common Cause CDS survey, indicated that people have more trust in army. 54% people informed in the survey. Whether Hindus or Muslims, it is believed that upper caste were more likely to have a favorable response for police than their backward castes. Whenever violations of human rights are violated by police, it causes an overall loss of faith in the police as the protector of citizens' rights. The failure to respect human rights in everyday police process alienates the public sympathy and support, which ultimately leads to the undermining people's confidence in police. Moving forward, there had been many cases in the history over and over again where there has been a clear and very deep breach of the rule of law. Like for example, we can take Unnao rape case. In the second instance, in COVID-19, when no country, even the best health facility in the world, could find a cause or cure for the disease, a rise in the death toll. No health facility was available. When the central government announced the lockdown 1.0, There was a great stress on law enforcement agencies such as police to prevent the citizens to walk out for their own safety. In the case of one Sataria Hembrom and six other migrant workers, exhausted all of their savings during COVID 19, left with no other option, walked almost 1,800 kilometers from Mumbai to reach his home in Jharkhand, trekking upon 45 kilometers a day and going without food. And at the borders where they were going, they were lathi charged, but were not even asked a packet of biscuits by the police officials. In the third instance, Arnab Goswami's case, as we being the law students, we clearly have a very good hand in the journalism.
Saksham,
We know the journalism. We know the rights.
Saksham, sorry for the
In the fourth,
excuse,
yes,
Saksham,
ma'am.
sorry for the interruption. You have a minute to wrap up. So quickly come to your
Sure, sure,
conclusion, please.
sure. In the fourth instance, Hathras rape case, it was one of the biggest matters, highlighted matter in the country, where there was a clear breach of the rule of law in which the police officials, with not even arrested the accused, but burned the body of the victim because uh, the accused was a son of the MLA of the present political party. As we observed, in the above mentioned cases, the rule of law was clearly broken in the most evil manner. The concept of rule of law is the building block in which the modern democratic society is founded. The rule of law is just one of the virtues which a legal system may possess and by which it is to be judged. In RV Secretary for the Home Department, 1998 AC 539591.
Thank you, Saksham. Thank you for your presentation.
Just half a minute and it will be over. And as you know, my luck is a bit hard today. In RV Secretary Lord Steyn, sitting in the House of Lords, said, unless there is a clearest provision to the contrary, Parliament must be presumed not legislate contrary to the rule of law, and that is the very deep importance of the rule of law in Indian society. One of the best judges of the India and of the Supreme Court, Justice Nariman's favorite subject is rule of law. And he once said in the Sabrimala judgment, the duty to do so arises because it is necessary to preserve the rule of law. And if those whose duty is to comply were to have a discretion or whether or not to abide by a decision of the court, the rule of law would be set at naught. And as you all know, my time has come to an end, so I would like to just quote a very beautiful line I found out today itself for the rule of law. It was said by Dwight Eisenhower. The world no longer has a choice between force and law. If civilization has to survive, it must choose the rule of law. Thank you so much. Thank you so much.
Thank you so much, Saksham. And I would like to express my thanks and gratitude to all the participants. You all were amazing and with great ideas.
Thank you to everyone for joining us for this event.
For this,
So, yeah,
so
we'll end it here.
we'll end here.